figuring out a clicker, but we can get started. So in the last discussion also, we heard something about, some references to the DPDP Act. And I'm sure Mugbeel also asked, how many of you all have heard about DPDP Act? I saw too few hands go up. I'm assuming that's because of lunch fatigue. And a lot more people know about the DPDP Act. A lot of the people here I know are regulated entities, which means that data governance and information security related compliance is not new to most people here. There are sectoral regulators, RBI, SEBI, that already provide these governance frameworks and compliance frameworks, and a lot of the people here have already been complying with those frameworks. But with the DPDP coming in, there is an additional layer of complexity that gets added to your already ongoing compliance mechanisms. And I'm here to tell you what are the problems, what are the problems that you will face, the challenges, the practical challenges in complying with DPDP, and what can be the potential solutions, complete with flowcharts and various illustrations that we are going to discuss here. By the end of this discussion, my hope is that I'll be able to give you an overview to start brainstorming internally about what these solutions could be. If you're evaluating third vendors who are offering these solutions, you will have a good starting point. And it can serve as a starting point for our discussion about DPDP compliance as well. So I'm just here to share the knowledge with you all. And while I'm doing that, I'll try to put in a pitch as well. So let's see if this works. Yes, it works. Who am I? I'm Pushkal. I head Consent Infrastructure at Leegality. I used to be a lawyer. I'm an ex-privacy lawyer. I worked at Trilegal. I've worked on the DPDP Act when it used to be the PDP bill. And I've worked on international regulations around privacy and within the BFSI space as well. Now, for the last few years, I've been a product manager. I've been building compliance products within the BFSI space. So when we look at the DPDP problems in the DPDP compliance space, we are wearing the hats of lawyers as well as techies. And we are bringing together the legal solutions in a technical and practical way. And that's the sort of information I'm here to share with you all. Now, there's going to be a few topics that I'm going to try and cover. We may go past time, so I may skip some topics. But the first one is collecting consent. Now, we all know that in DPDP, you have to collect granular consents. And in typical website or application flows, this is pretty simple. Like there's a pop-up, you collect the consent and you store it, right? But all those conditions for consent collections are not all simple, right? You can have physical flows. Most BFSI customers are still filling paper forms, right? How do you collect consent for digital personal data through a physical form? Or when you're dealing with agents, right, who are third-party agents or channel partners who are selling your services to the customer, where you don't have an interface with the customer. How do you collect consent in that case? So let's talk about collecting consents in difficult conditions. Before we do that, let's briefly understand the requirements under the DPDP. Firstly, you have to collect consent for a specified purpose, right? So the consent has to be granular, that's new, right? You also have to allow the user to withdraw that consent at any point in time. That's also new, right? And withdrawing should be as easy as giving consent. You have to show a DPDP compliant notice. There's a bunch of requirements here, many languages, itemized list of purpose data categories, a bunch of stuff. And then you have to maintain verifiable records of the notice and consent. So it's ever assailed. If anybody ever asks you, was consent given, you have to be able to produce a verifiable record to prove it. So how does that work in a physical flow? Well, what is a physical onboarding process? Very simply, the customer fills out some sort of a form, right? And that data is digitized either with the customer in front of you, or that data is taken to some sort of a branch, back office, and digitized with the customer away, right? Pretty simple. Let's look at, but all the information that is entered by the customer is entered on this physical form, right? These days, a blanket consent is also collected on this form. But how do we collect a granular, verifiable consent in these cases? Well, these could be potential solutions. If the customer is with you, that is the best, right? You can collect a consent using the device that is available with the agent or a branch employee, right? You can uniquely identify the customer with an OTP at the time of providing consent and collect that consent on a device like any assisted flow runs right now and store a verifiable record of that consent. If the customer is away, a good solution is what we have in the middle here. As soon as you digitize the data, the first thing that you should do is trigger an IVR or an SMS to that customer through which they can provide their consent. Now, some of these customers may not have smartphones, they may have feature phones, right? Which is where IVRs and OTPs become your friend for collecting digital consent. The goal here, what we're trying to do, is digitize consent at inception. The reason that's important is because this digital record is going to later help you in governance, in making decisions about whether you reach out to this customer or you don't reach out to this customer. If you reach out to a customer who has not given their consent, you're incurring a 50 crore risk for every single instance of violation, which is why it's important that you get this right. Which is why I'm not a big fan of the third solution, which is uploading a scanned document. If you're collecting consent on a paper, you could store a verifiable record by uploading a scanned copy of that paper in some sort of a database. But this might be fine for maintaining a verifiable record. But now, how do you change this into digital consents, which are going to be used to process the data further, right? You're going to either use OCR or manual entry. Both of them are error prone, which means you're incurring a percentage chance of a 50 CR fine, and you're increasing your risk. So first solution, not so great. The other two solutions work out fine. This is something to discuss when you're thinking about how to bring in consent in your physical flows. What about when a third party collects the data, right? One very good thing that has happened in India and in India alone is that this consent record that is created is interoperable. What does that mean? The government has come out with a standard for collecting all consents back in 2017 when they were just kicking off the account aggregator project. And account aggregators are collecting consents in this interoperable format. What that means is a consent that is collected by party A can be read and understood by party B. So when you're collecting consents through a third party, the consent request or the UI, the pop-up, can be shown by that hexagon in the middle is a third party. So the consent UI can be shown by the third party, but the records can be maintained at the business end, right? This is possible in India because of interoperable consent records, right? And this is something that you can do when you're integrating with your DSAs, with your channel partners, with your aggregators, etc. Let's move to the next topic. How do you manage third-party risks, right? How to not rely on contracts and indemnities. So typically the way it works right now is that you have these structured contracts where it says, okay, you will take all the consent that's required, you won't process data when I don't tell you to, and if you do anything, I'm going to give you, you're going to pay me the damages, right? That's typically called an indemnity. Right now, if any third party makes a mistake, or if any third party uses data in a wrong way, you are going to incur a fine of up to 250 crores per instance, depending on the violation. If you pass that on to that third party vendor of yours, they're going to shut shop, file for insolvency, and walk away from the problem, right? So the 250 crore fine is still yours to pay, right? So now your measures to prevent third party risks need to be more preventative, need to be more proactive, right? What are the requirements that come in for third parties, right? First is you must check for consent before sharing. Let's say you're using a CleverTap Twilio for your marketing campaigns, where right now you can have a pipeline for sharing your data with them, but going forward, you're going to have to segment that data based on where you have consents, right? And you have to check for consent before you share that data. Further, you have to delete data across internal and third-party systems if that consent is withdrawn. So on a proactive basis, users can come to you and withdraw their consent, and you have to get that data deleted, right? And you have to assess and audit vendors. This is something that has been going on for a while, audits and privacy assessments. That is something that you have to do. Here also there will be a few additional questions and a few additional dimensions to your assessments. We know that BFSIs have massive exposure to third-party risks. When a customer thinks that they're talking to a large business, they're actually talking to an entire ecosystem of systems, right? They're not an ecosystem of third parties when they're having any transaction with that third party. And that's why BFSIs have a huge exposure, right? What are a few of the things that can be done to resolve this exposure, right? Firstly, you should do your vendor privacy assessments. I must say all of these processes should be automated because these are all compliances that are piling up on you and you have to do your business as usual. So these processes, you should try and automate them as much as you can. So, of course, privacy assessments, not going to spend too much time on that. Mandatory consent checks, right? Before you perform any operation about a customer, be it sending a message, be it providing them a service, be it doing anything that is optional for the customer, you must check if consent exists. And if consent exists, only then you should perform that operation. Automated deletion is very important. If a customer withdraws their consent, you have to make sure that their data is deleted in all third-party applications that are using their data for the purpose for which they've withdrawn their consent, right? And you have to maintain a data mapping. This is critical from the point of view of any third-party risk you may incur, be it personal data breach, be it getting data deleted. For any user who performs any action, who withdraws any consent, you need to know exactly which system should delete their data, like exactly which system their data is lying, which is why in order to achieve all of this, you need to do your data mapping. Your data mapping needs to be in place, right? Delete by default. We spoke about data retention requirements. This has changed massively. So a bunch of sectoral guidelines required you to store personal data for a minimum period of time so far. Now with the DPDP Act coming out, these minimum periods have become maximum periods. Beyond that, you have to delete the data. Furthermore, for something optional, which is not legally required, you have to delete the data when the purpose for using that data is exhausted, right? So the law is telling you to delete your data by default. If you don't have a reason to use it, you delete that data. Now, how do you achieve something like this? Well, the answer to this can be understood in two ways. The first one is for optional purposes, right? Well, you should, for any purpose that's optional, you define the expiry periods for your consent against that purpose, and then you collect consent against that purpose. You maintain a verifiable record of it, record of that consent that tells you the date on which that consent was collected. At the end of that expiry period, you can trigger fresh consents, or you can delete the data mapped against that purpose. If you fail to do this, if you use data beyond the period for, like optional data for beyond the period for which it was consented, again, you're incurring a risk, which means this whole process has to be automated and error-free, right? What about when the retention is based on legal requirements? So typically any legal requirement, let's say a policy claim, an investment record, or a KYC record, right? All of them are based on the date of account closure or end of business relationship, right? So you simply take the date of account closure, you add the applicable data retention schedule, and based on that, you trigger a deletion of that data across all the internal and third-party systems, right? And this is something that we are doing in Leegality Consent Infrastructure, right? Now, while we were figuring out these data retention schedules, we realized, well, there is a lot of data retention requirements across these sectors. So we read all of them. We put all of them on these infographics, which for banks, NBFCs, insurers, where for each data category, we tell you the retention period and the date based on which the retention period starts. And we've put together all of these infographics in very easy to understandable way for the tech audiences. And we put it all in our data retention guide. Here's a QR for that data retention guide. If you want, you can scan this QR. It will take you to a form where you can download the data retention guide. I'm seeing some phones in the air. I'll just pause for a second. Cool. So this is how you can solve for data retention, right? Now let's talk about personal data breaches. We just spoke about personal data breaches. Now with DPDP coming in, there is an added flavor to personal data breaches. You now have to send 3 notices, apparently within a 72-hour time period. 2 of them have to be sent to a new data protection board, and 1 of them has to be sent to the user in all cases. This, as of right now, is over and above your notification requirements to RBI and to certain, or to SEBI and certain, or whichever regulator and certain, right? So there is a lot of notifications. There's a lot of coordination, right? Which means that you need to be ready for this, because during a data breach, you're dealing with, mitigating the risks that are coming out of that data breach. You're dealing with, protecting your data, managing your data loss. These compliances is something that you need to have just running on automation, right? Because now, when you notify the user, you will also have to address their questions and concerns, and there's going to be a lot of panic that is going to come up. So the data mapping that I was talking about, if you have that data mapping done once and you're collecting consents through a structured platform like Leegality Consent Infrastructure, it helps you identify immediately who are the impacted customers, and trigger a workflow for sending them the necessary notifications. This is, of course, something that you can build yourself. This is something that other solutions might also have. But this is the right approach, is what I'm here to say. You're going to have to need to automate these notifications, automate these compliances as much as possible, especially in a data breach in such a sensitive time, right? So, of course, all these problems and solutions, we've been working on this for the last 1.5 years, and we have put them all together in Leegality Consent Infrastructure, right? We allow you to do your data mapping. You can manage your consent collection and withdrawal and integrate it anywhere. When I say anywhere, it's a bit of an overstatement, but literally you can integrate it in email, SMS, WhatsApp, branch, agency, web application, third parties. So highly available consent collection and withdrawal mechanisms. Perfect auditability based on digitally signed records. You can manage your data principal rights, DPIAs, and your third-party risks, right? So this was a very brief presentation. I hope that all of you all walk away from this with an overview of the sort of solutions that you need to look at when it comes to DPDP Act. If you want to have more of a conversation about it, please scan this QR, fill a form, and we'll be in touch with you. So thank you so much. If there are any questions, do we have time for questions? We don't have time for questions, but we are available right outside at our booth. We'll be happy to chat with you. Thank you.